to work out how to find a space, or find an appropriate point to close the project, because you're right. And certainly in the Australian context, about the continued existence of colonial experiences or practices in relation to certain populations. And in the Australian context, when I've talked about this work, even to talk about a post-colonial space is actually very controversial, because the argument of Indigenous peoples is that actually there's nothing post about colonialism in Australia, and that there's a title of a book that's come out about a year ago called Just Another Day in the Colony. So in other words, Indigenous people are still living colonial experience. And it's by an academic, it's a great book actually. And I will read the article about when was the end of slavery. That sounds really interesting. I think it's going to be challenging to think about. So in the mid-20th century, in the rise of the human rights movement, the end of and independence movements, the kind of idea of the empire shifted to trusteeship, as Brian Simpson would argue. But then, of course, the formation of the Commonwealth raised all sorts of other kinds of supposedly benevolent kind of legacies or continuation of colonialism. And one of the things I thought I might do in the project, it's not in the paper, is look at the particular conference called the Commonwealth Law Conference, I think it is, or Commonwealth Legal Conference. And it's not something that is an academic conference, it's actually a conference of practitioners, but it takes place around different parts of the world, in Africa, in the Middle East and elsewhere. And it seems that the practice of bringing Commonwealth lawyers together through this formal organisation might itself be an interesting way to think about, like it's kind of an institutional way of thinking about where end is and where it's not. I don't know, it's not a very good example, but I think I need to find some kind of way of telling the story of both change and continuity. So one of the things that someone critiqued my most recent book about was the idea that I was writing about Australian law before Australia had formal legal status. So before the common law was Australian in a meaningful sense. That was Peter Kane. And it was at the time I was like, oh no, I can't do this project, it's gone. But actually it worked out that it was an incredibly good provocation, because it really made me think, right, what is it that, why do I see Australian law where he sees no formal existence of independent Australian law? And the answer is because he's not a criminal lawyer, and he was telling the story from a constitutional perspective. And if you just tell that very formal story, you don't see meaningful existence of something with national coordinates, which I argue in the book had actually predated that formal independence by a number of decades. So it's things that I think are finding a way to tell the story that will, if you have any insights, let me know. But I think that's a good point.
Thank you on that. Thank you.